We're going to talk about patents today, but there's actually 4 kinds of intellectual property protection. So I'm not going to talk about patents because that's the whole talk. Copyright. Copyright is a way to protect something. So if you write a poem or a story or sing a song, anytime you put it in a tangible medium, something that somebody else can access, you automatically have copyright for your idea, or not your idea, for your poem or your song. You can also register it with the US, with a Copyright Office, which is not part of the Patent and Trademark Office, but a separate office. You can submit your story or your poem to the Copyright Office, and that gives a more formal notice to people that you have copyright protection. Trademarks, we're all familiar with trademarks. We see the little R with a circle around it next to Nike or next to Dunkin' Donuts or something like that. That's a registered trademark. So they took their words or their logo and they went to the trademark office and they got a registered trademark. They fought for it at the office. If you have something, say you have a website or you've got a little store that's called Joe's Chocolate, you could do Joe's Chocolate with a little TM. And that means that you're establishing ownership for that name, but it's not registered with the patent office or the trademark office. So it does give you some protection. It's just not formally recognized by the office. And the last thing is trade secret, which is actually a pretty good type of intellectual property protection because nobody knows what your idea is or your invention is. And that's assuming they can't reverse engineer it, which is always a possibility. But it is one way to protect your ideas. So we're going to do, when I learned it, it was who, what, where, when, why, and how. But I'm going to take them in a different order. We're going to talk about what a patent is, who can file for a patent, why bother filing for a patent, when should I file, where do I file, how do I file, and what happens after I file it. I'm going to focus on the US because it's actually the best market for every patent invention in the world. And there are some changes in the patent law that came about in 2013. I'll talk a little bit about that. And I'll talk a little bit about how the US is different from the rest of the world and how we've actually harmonized our process to be a little bit more consistent with the rest of the world. Before we talk about what a patent protects, we have to talk about what makes something an invention. So if I stand up here and say that I wish I had a truck that drove itself and plowed the driveway at the same time, it's not an invention because I don't have any idea how to make that, right? I haven't put in any detail. It's just a wish. So something that's an invention has to be a solid idea. You have to have details about that idea. You have to know how to make it. And you don't actually have to make it, but you have to know how to make it. And if you can make it, that's always best. So it has to be more than a wish, and it has to be useful. So the classic example from the patent office is we don't need any more landfill. So an invention of something to fill a landfill is not really useful. We have plenty. But if you invented something to help degrade what's already in the landfill, that would be useful, and that is something that you could patent. And it has to work. This kind of makes sense. It's kind of doesn't make any sense to file on something and get a patent for something that doesn't work. And the patent office is made it clear that you cannot patent abstract ideas, laws of nature, or natural phenomenon. So when Newton discovered gravity, he couldn't file a patent application for gravity. There was no way that he could own that. I know Pfizer's in the area, so everybody's familiar with drugs. Pfizer can certainly make a drug, apply for a patent, and get a patent on a drug, but they can't make a patent or apply for a patent on how the cell processes that drug. That's something that occurs in nature, so they can't actually own that pathway. They can own what they put on the cell, but they can't own what happens inside the cell. So now we can talk a little bit about a patent. There's 3 types. There's plant patents, design patents, and utility patents. So plant patents are just what you think they are. If you breed a new kind of strawberry or a new apple tree, you can apply for a patent and get patent protection on your new plant. Designs are what they sound like, designs for your chocolate bar, designs for your lipstick containers. You can actually patent your designs. But the one that I think people think about the most is a utility patent. So that's on your drugs, on your staplers, on your whatever, the things that people use. It's a utility application. So a patent is kind of like a deed. It gives you 20 years of exclusivity for one invention, and at the end of that 20 years, your invention becomes public knowledge. And that's your trade-off. That's what you agree to when you apply for your patent and get your patent issued. And the interesting thing is that it gives you the right to exclude. So you'll see 20-year term of exclusion and the right to exclude, and we're going to talk about that because that's really important. If you think of a property and you think of a boundary, it gives you the right to exclude people from coming on your property. And that's exactly what a patent will do. It will prevent people from having the right to use your invention. So this is what is determined by the Patent Office to be the first patent. So it's 1790. It's to Samuel Hopkins of Philadelphia. And it's an improvement and an apparatus to make potash. It's a 4-step method. It was signed by George Washington. And if you can read, it's in legalese. So legalese has existed since the very first patent. There's a whereas, and not known or used before. So it's been around for a long time. This is probably the shortest patent. Now there are hundreds and hundreds of pages, but this is actually the first patent. So what does it mean for an invention to be patentable? It has to meet the requirements of the legal laws. So in this case, it's 35 USC. Those are the patent laws. 101 is utility, usefulness. 102 is novelty or newness. And 103 is non-obviousness, which we'll talk about each of these. So 35 is the laws. 37 CFR are the rules. So that's basically the Patent Office's explanation of their laws. And then there's something called the MPEP, which is the Manual of Patent Examination Practice. And that's actually the book that we studied to take the patent bar. It's actually the book that the examiners use when they look at your patent application. So we both have the same book. We're both working from the same book. We're just coming at the invention from different sides. This is what 35 USC 101 says. And I do have a couple of quotes from the law. I'm not going to read them all verbatim because I think that's kind of boring. But this one's short. So, and I have to say, every word matters. Every word in these statutes matters. Every word that's not there matters. So it's actually kind of a tedious business when you're trying to figure out what the Patent Office is teaching and does or doesn't want, because it's all in there, and sometimes it's not in there. So whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement of one of these can obtain a patent, subject to the conditions and requirements of this title. And there are many, many, many conditions and requirements of the title. What does it mean? And what I'm going to do is go through 101, 102, and 103 and kind of give you a little translation of what each one is. So we know we know that an invention or discovery can be patented. And we know from 101 that you can patent a process, a machine, a manufacture, or a composition of matter. And one thing to notice here is that it's new and useful. It has to be both. It can't be new but not useful, because we've already learned that it has to be useful. And it can't be useful and not new, because if it's not new, then it's already known in the art, so it can't be patented. So it has to be both new and useful. And that's what I mean when I say every little word matters, because if there was an or there, that would completely change the meaning. But it's not, it's an and. It has to be new and useful. And the other thing we see on this list, or we don't see on this list, are the natural phenomena, the laws of nature, and the abstract ideas. So that just reinforces, because they're not on the list, they can't be patented. And I think the other thing to point out is that back here in 101, it's a process. It's not plural. It's a machine. singular, a manufacturer. So for every patent, you get one invention. You can't get 5 inventions in one patent. You can only get one. And the office will cut up your application to make sure that you only get one in your patent. So I think when we go through and talk about the different concepts, since I asked you not to tell me your idea, we're going to pretend that the invention that we're looking at is a stapler. And this particular stapler sounds an alarm when there's 5 staples left. I don't know if you've ever worked in an office and you go to use a stapler and there's no staples in it and you just think, man, how could nobody notice, right? So our pretend invention is this stapler that lets you know when there's only 5 staples left. So this is 102, and it has to do with novelty, and this has to do with the new aspect of your patent. I'm not going to read it all, and I'm going to give you, if you would like to read it, I'll give you a moment to read it. It's a lot of language that basically says if your invention is already out there, then you can't go ahead and try to patent it. So the translation is, it's not described by someone else. So this is anybody else. It can't be described in a paper or a talk or online or in a patent or in a publication. It can't be in public use. So if I invented my stapler and I used it in the office and 50 other people in the office saw it and got a chance to play around with it, then it's in public use. I might not be selling them, but if I were selling them, that's another way to put your invention out in the art. And it's by anyone, anywhere in the world. So my little stapler, if I want to get a patent on it, has to be new compared to all the other staplers in the world, which is not always easy. So all of these things together, like the paper, the public use, the item being on sale, that's all considered prior art. And you'll hear that term a lot when you hear about patents. I think I might need my glasses. And this is where the United States differs from the rest of the world. So up until March of 2013, the United States had a first inventor to file. So if I invented my stapler 10 years ago and documented all along for those 10 years and filed, I could rely on my date from 10 years ago because that's when I invented it. After March in 2013, March 16th, we went to a first to file system. This means that the first person to file on that stapler could possibly get that stapler. Now it has to be their idea. They can't file the patent application on my idea. So if one of you guys runs out of here today and goes to file an application on a stapler that lets you know when there's 5 staples left, you can't do that because it's not your idea. But I think the key thing to remember is that it has to be your idea. So you don't want to be in a rush to file, and we'll talk about that in a little bit. One of the reasons we did that is that's how the rest of the world works. So the rest of the world, it's first to file. And it was really causing a lot of difficulty in prosecuting applications in the United States and prosecuting applications in Europe and China and Japan because we had such different rules. But in the US, you have a grace period. So I told you about my stapler today. So I have 1 year. So June 9th of 2017, I have 1 year where I could file for a patent application on my stapler. Nobody else gives you that. So by talking about it tonight here, I can't file for it in Japan or in China or in India. So patents go country by country. We'll talk a little bit about that. But the grace period is only for the United States. So that's another reason why you don't want to be telling people your invention. Because if you tell them about it, not only could you jeopardize your ability to file in the United States, but you jeopardize it all around the world. Okay, so this is obviousness. And it's exactly what it sounds like. So for 102, the one that we just looked at, your invention has to be out in the art exactly as it is. So somebody would have to have made a stapler that sounds an alarm when there's 5 staples left. Obviousness, it puts a twist on that. It's, well, what if somebody had a stapler out there that sounded an alarm when there were 3 staples left or 1 staple left? So is that close enough to make my invention obvious? So basically it boils down to, is your invention different enough from other similar inventions? And different enough is a really difficult thing to define. Patent Office has struggled with it for a long time. It's a legal determination, so a lot of people have the tendency to say, well, if I thought of it, anybody could think of it. But that's not what makes something obvious. The obviousness is determined by the Patent Office from information that was already in the art. So it's not your opinion, it's not the examiner's opinion, and it has to do with the information that was there and available and this imaginary person called the posita, or the person of skill in the art. So when they try to determine if your application, if your invention is obvious, they're going to say, well, anybody who makes things that fasten paper together would be the person of skill in the art, and they would be the person who could possibly make your invention. Some things, let's look at our stapler. Some things that the examiner might say could make my stapler obvious is maybe there's a riveter out there. A riveter secures things together. My stapler secures things together. And maybe that riveter sounds an alarm when there's only a few rivets left, so that the person at that machine can put more rivets in. So the examiner could take that and cite that against me and say, well, here's something that clips things together and sounds an alarm when there's not a lot left. So for a little bit more on obviousness, as I said, the information has to be out there. So if they can combine, if the examiner is going to say, well, I can combine this and this and this and make your invention, and they're going to say it. They always do. It's the hardest argument to win. It's usually the last argument when you're prosecuting your application. So they're going to combine something. They're going to say, well, you had your stapler. What about some kind of paper clip that maybe could clip these papers together in the same way? So they're going to make some kind of substitution. It's obvious to try what you tried. That's another one that's really difficult to get over. They're going to say, well, anybody who was making office products would know that you could make this stapler and you could put an alarm on it. So all that information out there has to teach or suggest or motivate that imaginary person to make your invention. But it can only be that information that's known at the time that you filed your patent application. It can't be something 10 years later or 5 years later. It has to be what was known when you filed. So we know what a patent is. It's a document, a legal document, that has passed scrutiny by the U.S. Patent Office, and it defines one invention. We know that it's useful from 35101. We know that it's novel from 102. It's different from everything else out there. And it's not obvious. We know that from 103. It's something you own. When you get your patent, it's something that you actually own. It empowers you to exclude others from practicing your invention. And you trade it off for 20 years, that exclusivity, and then in 20 years your invention is something that becomes public. And I know it sounds pretty simple in here to get by 101, 102, and 103, but it's not. It's not easy at all to get past these things with the Patent Office. It requires a lot of arguing. This is patent number 1 from the new patent numbering system that we use today. So the numbering started in 1836. And it's for a steam engine. And it's always fun to go back and look at these old patents, because you think, oh, I can't believe that that was invented so long ago. Or it's actually kind of interesting. It's an interesting look at history. And still the legalese. Be it known that I, blah, 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 and there's all kinds of legal language in there. So it never went away out of the patent system. So who can file for a patent? anyone. 101 says whoever invents or discovers. 102 says a person. So it's really fun for all ages. But I work at a little law firm with an attorney and his daughter. He filed a patent application on behalf of his 10-year-old daughter, who came up with an idea for a fashion, I'll call it a fashion accessory. And she's an inventor. So they're going to be prosecuting that through the patent office and see how it goes. So really, anybody that has an idea can apply for a patent. It can be any age. And you probably guessed what I'm doing now. I went from patent 1, now I'm going to patent 10,000. I just put these numbers in randomly at the search engine. This is the 10,000th patent. It's in 1853, so in only 17 years, the Patent Office issued 10,000 patents. So it's actually a very busy place. And that is a paddle wheel. And I have to say, figures have not changed much from the 1800s to now. They still have to be clear, they have to be labeled with their figures and all their little parts, and they're all described in the application. So it's kind of cool. So probably this is one of the biggest questions, is why file for a patent? It takes time and it takes money, so why do it? It's that right to exclude. So it's the right to exclude somebody else from making your stapler, from selling your stapler, from importing your stapler, and it gives you leverage so that you can collaborate with somebody. And this is, so patents are country specific. If you want to file a patent on your invention in the United States, you'll get protection in the United States. If you want to get protection in China, you have to file it in China. If you want protection in Australia, you have to file it in Australia. So it's good to know where your market is, because it's very expensive once you get out of the United States, because you have to pay translation costs and all kinds of things. Doesn't mean you shouldn't, it just means that you should understand what those costs are. So patents can be offensive and defensive as well. If you, especially the drug companies do this a lot, they might file a patent application on something that they're never going to develop, but because they filed that application and put that invention out there, somebody else can't develop it. So that would be offensive. Defensive might be if somebody's drug patent is out, your patent is out there, and somebody is trying to file something that's close to your invention. You might file other formulations or other versions, and those are all defensive. You may never go for those. You may never try to put those in clinical trials, but it's a way to deal with the competition. So when you get your patent, you own it. So you can frame it, you can sell it, you can license it, you can leave it to your children in your will. It really is like a deed to a piece of property that lasts for 20 years. So this exclusion that we've talked about is actually kind of a frustrating concept for a lot of people, because basically it means you can patent something, but just because you patented it, it doesn't mean that you can make and sell it. And this is the difference between patentability and freedom to operate. So the classic example that everybody uses is a mug. So US patent number, and we refer to them by their last 3 numbers. So patent number 567 is for a smooth ceramic drinking vessel shaped like a tube. So that's a glass or a mug without a handle. Then you file a patent application and you get your patent issued 678. It's a curved ceramic handle. So if we want to make a mug with a handle on it, we've got to work together, because somebody owns the cup and I own the handle, right? So we have to work together. I'm preventing them from making a mug with a handle on it because I own the handle, and they're preventing me from making a mug with a handle on it because I only own the handle, and that's not really very useful if you want to drink something, right? So we could apply this to our stapler example too. Let's say somebody has a patent for a stapler that our original invention, a stapler that tells you when there's 5 staples left, but I come along with some kind of gizmo that loads that stapler up. So if we work together, we could have a stapler that notifies you and loads itself with new staples. But we couldn't, separately we can't do anything. I just have something that puts staples in a stapler, and they have a stapler that makes an alarm, but we can't use each other's inventions unless we cooperate. So that's the exclusion. So we've already answered these questions. Can 567, which is the cup, make and sell a cup with a handle on it? They can't. They've been prevented by my patent. I've excluded them. 678, that's me. I can't make and sell that because they've excluded me. They own the cup and I only have the handle. So that's the power of a patent. It gives you the right to stop somebody and it gives you the right to enforce. I could make 1 million handles, but what good is it? And they could make 1 million cups, but they couldn't make a mug. That's what's the power of exclusion. So what about patent number 789? And that's a machine that makes a smooth ceramic drinking vessel shaped like a tube with an attached curved ceramic handle. Now, can they sell those cups, mugs? They can't sell them. They can sell the machine to make them, but they can't sell them. So it's a frustrating concept for people because they think, well, I have a patent. Why can't I practice my patent? Well, because you don't have the freedom to operate your patent. Okay, this is patent 100,000. We're up to 1870. So in 17 years, there have been another 90,000 patents that have issued from the Patent Office. I don't think anybody's using these today, but I thought it was kind of interesting. I did this random. I just went 1,000, 10,000, 100,000. Okay, so when should I file? We know a little bit about prior art, so it actually makes the decision to file, and first to file is in effect, so the first person to file is generally the person that gets the patent, but it's not an easy decision. So we know that our invention has to work. It has to be useful, has to be new, has to be non-obvious. So we have to somehow reduce this to practice. And there's a couple of ways to reduce things to practice. You can do it constructively, so you can make a very thorough description of how to make your invention and how to use your invention. This is part of 102. You have to teach how to make and use your invention. You have to demonstrate to the examiner that you know what your invention is. It's more than a wish. So what did I wish for before? I don't even remember. I wish that I knew how to make a rocket to go to the moon, all right? But I don't really know how to make that, so I don't really possess that. It's just a wish. One of the interesting examples is mechanical drawings. So mechanical things tend to generally work as mechanical things. You can actually submit drawings, and that's generally a suitable proof that you know how to make and use that invention. Now you can describe it in excruciating detail. You can also make it. So those are called your working examples. So in some cases, you definitely need a working example, especially for drugs. So even though I might have described a drug in great detail, I really should prove that it works if I want to get my patent and get it through into trials and things like that. You don't have to submit working examples, but the Patent Office has a wonderful collection of working examples that people have submitted from ages ago. So there's probably a paddle, and there's probably a horse's sunbonnet, and all those cool things are probably at the Patent Office. For biological activity, it's kind of interesting. I don't have to prove that it works 100% of the time, but I have to prove that it works enough. So the Patent Office really has some interesting ways that it lets things slide. I mean, you wouldn't want to patent a car that only works some of the time, but we've all come to realize that every drug doesn't work on every person every time. So it has to be active, but doesn't have to be 100% active. Okay, so along with continuing on with when should I file, we've talked a little bit about first to file and first to invent. So if you were to file a patent application today, you would be under the first to file system. So you want to keep that in mind. But you know, somebody else can't file on your idea, so also keep that in mind. If you file too early, then you probably don't have enough. Your description in your patent application probably won't have enough detail, probably won't have enough examples, and when you go to rely on that later during prosecution, you just aren't going to have enough information. If you file too late, somebody could file before you, but they would have to have invented it independently. So if somebody in Oklahoma worked on this stapler and had no idea that I was working on this stapler and he filed first, that's my tough luck, because he had no idea. He didn't learn anything from me, so it was all his idea. So it's a tightrope walk, especially when you're thinking about drugs and pharmaceuticals. You have to have a lot of data when you file these applications, because you have to prove that you do have to prove it works. It has to do something, right? We know that it has to be useful and it has to work. So that's actually a tough decision to make, is when do you have enough? When do you have enough data? And it can become kind of contentious as in some practices. Oh, and the other thing I need to say too is when you file this application and you're describing your invention, you can't keep anything secret from the patent office. So it's called best mode. You have to tell the best way to make your invention that you know. You might learn something 5 years later, but when you file, you can't say, well, I'll just tell them 5 steps, but there's really 4, or there's really 6. You have to really tell them what your invention is. You can't hold anything back. That's part of the trade-off. So be prudent. Don't disclose your invention. That's why I said I don't want to know. It's fine if you want to discuss it with your significant other or somebody who's working on it with you, but I wouldn't go talking about it to all kinds of people. And you want to search for your invention. You want to convince yourself that your invention is something that's new and useful and not obvious. And you need to look all over the world when you do that. And I'll show you a couple places where you can do some patent searching. You should understand what the office wants. So a patent application is written in a certain way, certain size font, certain page. I mean, there's so many regulations to what the office will take for your application, so you'll want to become familiar with all those requirements. And be diligent. Document, 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 because you never know when somebody might try to steal your idea. So now we're up to the 1 millionth patent. We're up to 1911. It's the 1 millionth patent, and it's for a new kind of tire. So the last time we checked in, it's been 40 years, and there's been 900,000 more patents that have issued from the Patent Office. It's pretty amazing to realize what goes on there. So that's part of the patenting. You see the figures are still the same. Everything's all labeled. And I guess I'll say too here that the Patent Office is funded by fees. So when you file, you pay a fee. When they search, you pay a fee. So that is how the Patent Office is funded. It never seems to have enough money because other parts of the government come in and actually take some of the money from the Patent Office. So then the fees go up. But there's 3 tier layers for fees. There's large entity, which would be a corporation of 500 or more employees. There's small entity, which are smaller corporations. And then there's a micro entity, which is me with my stapler, or you with your whatever you've invented. And those fees are 1/4 of what the regular fees are. So the office is interested in your inventions, and they're making it more affordable for you to file. So I said, you can file at the Patent Office, and I just have a couple of windows open. That's the new face of the website. So there's patents, there's trademarks. You can do both at the patent office. You won't see copyright. Copyright is at a different office. They do have all kinds of tutorials and all kinds of information. There's a lot of slide presentations, and there's a lot of ways that you can work your way around in the patent office. So they want you to file electronically. That's EFS Web. You don't have to. You can still file an application on paper. They'll charge you extra for it. But they have a whole fantastic electronic filing system. They do want you to do that. You can pay your fees online. You can pay with a credit card. So over on the Get Started side, you see there's the patent basics, the process overview. There's searches. So you can search for patents that have issued at their database. You can do a quick search, an advanced search, or a number search. So here's where you would search patents. This is not publications, it's patents. And there's all kinds of ways you can search by a number, by a date, by the inventor name, and you can put all kinds of words into the query box, and you can look for something that's like your invention. And I would suggest when you do this to really think outside the box. So my stapler example, I brought up rivets. So a stapler connects two things together. It doesn't have to be paper. Rivets can connect things together. Paper clips can connect things together. So you really want to try to think of all the possibilities, of all the different ways that something can do what your invention does. So my detector, how do I detect that there's 5 staples left? I said, well, maybe there's a spring mechanism in there, and I measure the spring mechanism. So maybe I need to look for that. Maybe I did use a barcode reader and I read, so I need to use barcode readers for measuring things, not so much for reading a price tag, but for measuring something. Then I have my little gizmo to put the staples in the stapler. So there's got to be, you're going to want to look at robotics, and you're going to want to look at things that open things automatically. You got to open your stapler. Something that picks things up and puts those staples in. So you have to look at it from all different sides. It's not just your stapler. It's things that put things together and things that detect. Because that's what the patent office is going to do when they search. This is the World Intellectual Property Organization. So remember, I told you that your patent will be compared, your application will be compared against things all over the world. And you can go to WIPO and you can look for patents all over the world, in Japan, in Germany, in China, Australia. It's the same kind of search. You can put in search terms and look for your invention. The other thing you can do is just a Google search. So it doesn't have to be a patent or an application. You can just do a Google search. It could be something for sale in a catalog. Could be some guy on, what is that, when you raise money so that you can sell something. Yeah, somebody could be raising $10,000 to make that stapler, so it's already out there. So it could be anything, but these are the 2 places where are useful to go to for searching the patents. Okay, so here's the 5 millionth patent. We're up to 1991. So in the 81 years since we checked in, there's 4 million more patents that have issued. That's a lot of patents, but a lot of them have expired, right? There's been an awful lot of 20-year periods since 1911. And these are plasmids. If anybody wants to know about plasmids, I could tell you about them. But you don't have to worry about them. So we talked about you can submit your patent application with paper or electronically. And who can file it? Well, you can. You can go to the patent office and file on your own. You can use a legal representative, and we would file the application for you. And then the application is prosecuted. You are more than welcome to prosecute before the patent office. It's completely allowable that an inventor can prosecute his own patent application, or you can get a legal representative. So let's talk a little bit about what prosecution is. When you put your patent application into the patent office, they're not going to automatically give you a patent. They're going to come up with some reason. It might be a good reason. It might be a terrible reason why your invention shouldn't be patented. And you're going to have to argue back with them. You're going to have to explain to them what's different about your invention versus the other things that they showed you, the documents or the brochures or the patent applications. They're going to say in writing, this is why you can't have it, and you're going to say in writing back, no, this is why you're wrong, and the law says that I can have this application because these are the differences. It's tricky because everything you write to the patent office goes in the file. So your patent ends up with a file history, and every document that goes in and every document that comes out goes in the file history. And if you say something early in prosecution, the examiner could come back and use it against you later. So you have to be careful when you make your arguments that you don't argue yourself into a corner saying, yes, it's new, or it's not obvious for these reasons. You have to kind of be careful. And you can't do things like rely on something, like rely on a reference to say it's not obvious, and then you can't, you've said that that reference is no good. You can't use that reference to support yourself someplace else. So it's tricky. And they try to back you in a corner too. So there are 29 chapters in the MPEP. You are welcome to read them all. I did at one point in time. There's an entire chapter that's dedicated as to what you need to include in your patent application. There's several sections to a patent application. But the biggest sections are the description. So you have to describe your invention so that somebody else can make and use it. We talked about best mode. You cannot keep something back when you describe your invention. And the office calls these written description, which is the describing of your invention, and enablement is teaching somebody how to use your invention. It's not good enough to have one or the other. They have to be able to do both based on what you've written. And it can't be confusing. Some of the guidelines that I've heard in the past 10 years is you should write your patent application so your grandma could understand it, or you should write your patent application so a judge could understand it, because judges don't necessarily have a good scientific background. So clarity is really, really important. The other really important part of your application are claims. Your application will end with claims. And this is your property line. This is where you say, I claim a stapler that joins pieces of paper together, and when there's 5 staples left, sounds an alarm. That is my invention. I have to set it forth in clear and concise terms. I have to set those metes and bounds. This is the valuable part of your invention. All the stuff you described, that's just the description. The claims is what you own. And that description has to support the claims. So we talked a little bit about prosecution. You're going to get some kind of rejection. 101s are not that common because most people have searched and thought about their invention, so it's usually something that is patentable. You'll get a 102. They're going to say that your invention is out there. You're going to get a 103. They're going to say it's obvious, and you have to argue back. So right now, when you file your patent application, it's about 16 months, I think. 16 months before you get your first rejection. At 18 months, your application will publish. It's not patented, it's just published. It's no different than a book. You can request that it not be published, but every application will publish at 18 months. Then it becomes prior art for other people and for yourself. You are now prior art against yourself, and it can be used against you. Then if you are successful in your arguments, your claims will be allowed, your claims will issue, and then you have a patent. And right now, the whole process on average is 26 months. 26 months. But it depends on your art unit, so different patents go into different art units. My stapler would be in a different art unit than a drug, and which would be a different art unit than some kind of fancy gym wear or something like that. So, and different art units move at different speeds. Okay. This is the 9 millionth patent. Let's see. It was issued in 2015. So in 24 years, since we last checked, there were 4 million more patents. So right now, if you file a patent application with the Patent Office, the backlog is about 590,000 applications before you. But like I said, they go into different art units, so different art units move at different speeds. And just for fun, I just wanted to throw out a couple inventions that I think are kind of funny. This is obviously from like probably the 50s. It's just a way to hide your TV antenna, but I just wanted to point out every Tuesday, if you like, you can go to the patent office, and that's when patents that issue are posted. Every Thursday, the ones that are published are posted. This one is a referee doll that you can rip up if your team doesn't perform like you wanted to perform, and then you can put it back together. Some lady got this. I thought it was really funny. But this past Tuesday, I will tell you that 6,883 patents issued just on Tuesday, just in the United States. The highest number for that utility application was 9,363,000, blah, 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 blah. The 26,000th plant patent was issued, and the 758,000th design patent was issued. So the patent office is really very busy. Not surprised they have a backlog. And this one, this is a ropeless jump rope. And it was invented by somebody who liked to jump rope for exercise, but when he in his hotel room, he couldn't use a jump rope because it kept hitting the ceiling. So he invented this little gizmo that's weighted so that it feels like he has a rope on there, but he doesn't. So never think that your invention is dumb or not practical or silly. There's lots and lots of things that can be patented. It doesn't have to be a drug or something serious. There's actually websites that are dedicated to goofy things that are patented. One of them was a rabbit, and you would a rabbit puppet, and you would hide the needle in there so that when you were bringing your kid to the doctor for a shot, they would have this rabbit coming at this kid with a needle in. I'm thinking, well, that's not a very good idea, right? Your kid's going to be afraid of rabbits, but got a patent on it. So that's it. I hope it was fun.